We're so excited today to be featuring Cliff Snyder. I think I
Schneer,
got it. I might
Cliff
have
Schneer.
slaughtered it a little bit. But we're so excited to have him come on and talk about the essentials of special needs planning. As you know, special needs planning is something that all of us parents and caregivers really need to focus on because one of the critical questions we have is what happens to our children after we're gone, and setting up these trusts, setting up these able accounts, and doing all of this prep work really helps to relieve our stress, but also helps to prepare a good um, kind of landing plane for our children in the future so that we know that they're taken care of and there's protections in place for them. And so today I'm just really excited to have Cliff here, and he's going to talk about Meridian special needs planning and all of the different things that they do for caregivers like us who really want to just ensure that our children are taken care of at the end of the day. So Cliff, thank you so much for being here, and I'm really looking forward to your presentation.
Thank you so much, Michelle, and thank you for hosting this presentation and putting it together like this. And also, I'm glad to see that it's being recorded so that other people can watch it later. Um,
Mm.
yeah, so my name is Cliff Schneer, and the company that I own is called Meridian Special Needs Planning. And let me give you a bit of the background of both my company and myself. First of all, Meridian has been around in one form or another since the early 1990s, 30 years or so, under different names. Um, and it was founded back in 1991 in response to the growing need for planning for parents with children with disabilities. It was an unmet need, and so we got started back then. At that time, I wasn't part of the company, but I became one of their attendees, one of their first attendees at one of their first workshops back in the early 1990s. And the reason for that is because I myself have a son with autism. His name is Jesse. He is now, believe it or not, 40 years old. At the time I attended the workshop put on by predecessors in this company, he was 13 years old. And I knew that I had to find out what to do about his future, and I heard that this workshop was being presented. I attended it, and in the course of those 90 minutes, I came out armed with the knowledge that I needed, and I knew that it was going to save me a whole lot of time because the amount of research I would have had to do to get that knowledge myself would have taken me years as opposed to 90 minutes. So that's what I want to impart to you now in this workshop, since I've been living it for the past several decades myself. Uh, there, by the way, is my son Jesse. That photograph was taken when he was about 3 years old. He walked out in front of the rest of the crowd at a family picnic because he just wanted to get closer to the camera and see what was going on. There he is. He's adorable, if I say so myself, and he still looks younger than his age. He's 40 now. He looks 25. Why do we do special needs planning? Because this is something that actually really didn't, like I told you, my company didn't come into existence until like the early 1990s. Before that, there wasn't a whole lot. So why do we do it now? Well, one of the reasons is that, it's only been in the past couple of generations that the parents of children with disabilities actually the children are actually outliving their parents, because in the past, a lot of the disabilities that were diagnosed also had, shorter lifespans. For instance, Down syndrome. Um, Down syndrome life expectancies were only, 30, 40, 50 years old, uh, even less, up until mid-century, and then they started increasing. And now people with Down syndrome pretty much have the same life expectancy as anybody else. Um, Likewise, autism, persons with autism typically do have a normal life expectancy, What's different is that we're now diagnosing it, so we're recognizing, oh my gosh, we've got this issue with people with autism too. So the question is, okay, when should you plan? The answer to that is it's never too early and it's never too late to do special needs planning. Um, we have worked with families where the child with a disability was 4 months old, and we've worked with families where the person with a disability was 44 years old. And I've actually got one going on right now where the person is even older than that, in their 60s. But that's rare. But any time is the right time, and it's never too soon. You can always make changes to the special needs plan later as things develop. So, and also, let's face it, life has its hazards, and this might sound like an insurance salesman sales pitch, but it's always possible that something can happen to you on the freeway. That you might not might not make it through next week. Likelihood is everything's going to go as you normally expect it, and you're going to have a normal life expectancy. But the reason that we do estate planning and that we get, there are things like life insurance and stuff like that, is for the possibility that something happens, you know, out of sequence. We do this because we have to. The necessity for special needs planning is because uh, our children will outlive us, and they need to be provided for, unlike typically able children. So we have to confront this. It's difficult, but we have to confront it. It's not a pleasant topic for anybody in any situation, whether you got kids with special needs or not. People put off planning for their demise because you don't want to think about it. Now, like I said before, the four major topics are legal, government benefits, financial, and lifestyle planning. So we're going to get into legal estate planning first. And the first kind of legal planning we're going to talk about is the wills. Everybody's heard of wills. Um, you see it in TV shows and movies where a lawyer is reading the will out to the assembled family, and there's everybody gathered around the lawyer, and some get mad and some are happy and stuff like that. And this has created the impression that that's all there is to estate planning, just the will. Well, that may have been the case up until 50, 60 years ago, but now in addition to a will, you also have to have a revocable living family trust. And we'll get into that too. But before we do, wills, say with a married couple, wills are individual to a person. So with a married couple, the husband will have his will, the wife will have her will. Whereas when we get into talking about trust can be jointly held by and jointly created by more than one person. So let's talk about trust next. The first kind is the revocable living family trust. Now, this is something that families with any kind of children should have, and families with no children as well. A revocable living family trust is what we now call the quarterback of your estate plan. Um, it's where you actually do all the directing of where your estate is going to go. And in the case of a married couple, it's typically done as a joint family trust, especially in states like California and Arizona, where we are under community property laws. The family trust is normally a joint one. Whereas in other states, we work in Illinois as well. In that state, the family trusts are actually, the living trusts are actually separate for husband and wife. In the end, it doesn't make a huge difference, but here's the importance of trusts. When you pass away, if you pass away only with a will or with nothing at all, your estate gets tied up in a process called probate. That is, if your estate is anything over $60,000, $75,000, and most estates are, and the probate process takes 18 to 24 months here in Maricopa County, and it costs a lot of money. So it ends up reducing the value of your estate by 15 to 20%, and you don't want that. In addition to which, it has tied up your estate at a time that the funds may be needed to take care of your child. And until it gets out of the probate process, those funds can't be used. Let's back up a little bit. What are trusts in the first place? Trusts are this unusual concept. Um, they are an invention of Anglo-American common law from centuries ago. And you all know what corporations are. That is, when you create a corporation, that's a legal entity that has its own legal personality and can own things and can do things and own, hire and fire and transact business and so forth. Well, a trust is kind of like that too. It's not a corporation. It's not something that's created by filing anything with the corporate, government corporate offices and stuff like that. But it's created by creating documents and signing them and notarizing them. But once the trust is created, it too is a legal personality. It's a legal entity. So a trust can own things. I've got a living family trust that owns my major assets, and the house. It's it's the purpose of it is this: the trust is a living thing. The person who created it may pass away, but the trust did not. Therefore, if you have created a living trust for yourself, for your family, your husband and wife combo, uh, then what happens is when both creators of the trust have passed away, the estate does not go through probate because the owner of those assets has not died. The owner has carried on living because it's a living trust. It carries on. It exists. What happens, of course, after the mom and dad pass away is that the person they've named as the successor trustee takes over and distributes their estate, administers their estate in accordance with the instructions in the living family trust. So it avoids probate, and it gives all these instructions as to how to distribute the estate. So people might ask, well, that's what, wills used to give instructions as to how to distribute the estate too. So what do you need a will for anymore if you're able to create these family trusts? Good question. The answer to that is the wills are still necessary for two reasons. One is the possibility that someone might challenge the validity of the trust that was created and therefore it no longer exists, or it may have been revoked itself by you, or it may, for some legal reason, no longer exist. But what you've done is in your will, you are saying, I want my estate to be distributed in accordance with the instructions I've given in this trust document dated such and such. So even if the trust for some reason is declared invalid, the instructions contained in it can still be poured over into your will, incorporated into your will. So your will still stands and does the same things. However, it doesn't avoid the probate problems. You've still got the probate problem if all you've got is the will that's still standing. But the more important reason that you also must have a will is that's where you state who it is that you want to be the successor guardian of your minor children or any adult incapacitated children. The will, remember, is a public document. It's filed with the probate court, so people can go check it and see what it says there. So if, for instance, some ne'er-do-well relative comes jumping into the scene and wants to and claim responsibility and acts all caring and stuff about your child with special needs, when what it is that this ne'er-do-well relative really just knows that there's government benefits that he or she can siphon off for their gambling habit, then you can put in the will who it is that you want to be the successor guardians, and you can even state in the will anybody you would never want to be a successor guardian. So it's important to have in a public document that is available in public records a statement of who it is that's going to be that successor guardian. Now, this presupposes, by the way, that you have taken out an order of guardianship in the first place for any child with a disability over the age of 18. And and again, if you didn't do it when they're 18 or 19, you can still do it at any time, and you can have a limited guardianship as well. But once you have that guardianship, you also have to make provision in your will to say who after us, and that's where you put it in the will. So the revocable living family trust then is the, like I said before, it is the quarterback of the distribution of your estate. And you notice the word is revocable. That means when you've created it, you can also change it, amend it, add stuff to it, take stuff out of it, uh, totally revoke it and redo it and stuff like that. But it's a critical document for the management and distribution of your estate, and the as the vehicle for the ownership of your major assets. Now, next kind of trust is the kind that only happens and only arises in the case of families like ours, where we have a child with special needs. The special needs trust is a different kind of trust, and the most common kind, the kind that we create most often, is this kind called a third-party living irrevocable special needs trust. And that that's a lot to parse there. It's living because we create it right away, as opposed to something that's not coming into existence until off into the future. It's irrevocable because Social Security and Medicaid require it to be irrevocable for them to recognize it as a valid trust. Whereas the other one is revocable. They need to see this as irrevocable. In other words, that this is a real entity that isn't going to go vanishing on them. And the word third party means that it is created by someone other than the person for whose benefit it is. The third party in this case being mom and dad in most cases, or grandparents, or other friends, but it's not the person for whose benefit it is. So that's the third party. So let's see, the third party is the creator, and then there's the person for whose benefit it is. That's, I guess you'd call that the first party. Well, who then is the second party? Why do we have a number one and a number three? There's no second party in the picture. The second party is the trust itself. Remember, it's a legal personality, a legal entity. That's why it's called a third party. The third party are the creators. It's odd language, but that's what it is. So that's the most common kind of special needs trust. And once it's created, it has to get its own tax ID number. That doesn't mean necessarily it's going to be paying taxes right away, or even having to file a tax return right away, but it gets its own tax ID number. Once it starts earning its own income in excess of $600 a year, then it's going to have to file a tax return. Typically, these kinds of special needs trusts don't get funded until much later in mom and dad's life. So it's not an issue that arises early on when it's first created. Now, there's another kind of special needs trust, and we've seen this created by other lawyers, and it's called a testamentary special needs trust. And legally, there's nothing wrong with them. And what it is it's a special needs trust that doesn't yet exist. It's created inside the revocable living family trust in language that says, once both mom and dad passed away, there shall then come into existence a special needs trust for the benefit of Jesse Schneer, and that shall be the entity that receives any government benefits and so forth, or any funds whatsoever. So it's testamentary in that it is a testamentary document that says it comes into existence later on, but it doesn't exist yet. In law school, they would applaud you for coming up with a bright idea like that. That you created two trusts out of one document, pretty good. That's efficiency. That technically and legally by the book, it's valid. The problem is that you might run into an agent or representative of Social Security or Medicaid access in Arizona that doesn't see it that way. And worst of all, it could be an agent 30 years from now that doesn't see it that way. And then you created a problem for your successor, responsible people as to how to fix the problem. Whereas if you've created a third-party living irrevocable special needs trust right in the here and now, then we already know that Social Security approves it because we've got thousands of them out there that have been approved by Social Security in exactly the same format, and it exists in the here and now. So that also what that means is if grandma and grandpa want to leave something to their grandchild with a disability, they can leave it to that third party living irrevocable special needs trust because it exists right now. Whereas a testamentary special needs trust, as long as mom and dad are still alive, it doesn't yet exist. So it is not a valid beneficiary of anything that grandma and grandpa want to leave. And it also can't be a valid beneficiary of, say, a life insurance policy or, a contingent beneficiary on a 401k or an IRA. So you want it, we, it's our policy at Meridian Special Needs Planning to um, urge upon people to create their special needs trust as a third party living irrevocable special needs trust. We often see people come into our office with existing documents created elsewhere that have a testamentary special needs trust. And we say, well, it may be okay, it might work, but we don't know for sure. And it's our recommendation that we actually amend things here to create a living, a third party special needs trust in the here and now. So it's, you know, that's the way we see it should be done. Again, if you were to run into a Social Security representative that gave you a hard time about the testamentary special needs trust, you can ultimately appeal it to an administrative law judge, but who wants that expense and aggravation? I mean, I've had to argue cases up the ladder to administrative law judges because of wrong-headed decisions at the bureaucratic level at Social Security and at Medicare. And it's an annoying thing. And, the judges just shake their heads and say, yeah, you're right. I'm ruling in your favor. And it's just, it's just that you get certain agents in these government agencies that haven't been properly trained. And they have a lot of turnover in some of these departments. And so you don't want to have to fight this up the ladder to other judges. You want to get a ruling in your favor at the lowest level possible so you don't have those fights. Now, another kind of special needs trust that needs to be addressed because it sometimes arises is this one called a special treatment trust. Here's when this comes up. And it comes up probably in 25% of the cases that we work with in our practice. And that is if the person with a disability somehow does come into money on their own that belongs to them, then what has to happen is we got to get it out of their hands and into another trust, the special treatment trust, within 6 months of it arriving. And so, for instance, we had a family up in this part of town whose daughter with special needs was dispensed the wrong medication by Walgreens. And so they retained a lawyer and sued because it made her sick for a while. And so they got a settlement from Walgreens or Walgreens Insurance Company for like $50,000. Well, $50,000 is a lot of money. And as we're going to go into greater detail later, that is the kind of money that totally would disqualify their daughter from receiving any government benefits, which are really important. So what we have to do when that $50,000 comes in is move it from being titled in the name of the daughter herself into a special treatment trust for her benefit. And since it's her money in the first place, that means it's a first party trust. So it goes by another name too called first party special needs trust. Another example of that is I was doing one of these workshops back in the old days when we did them in person. And one of the dads came up to me after the presentation saying, well, my mother passed away 2 months ago and left my son $45,000. What do I do? And I said, well, we still got 4 months we can act on that. Let's put that as the priority for whatever we do with your family. Was first things first. Before we do anything else, we're creating this special treatment trust to get that money over, and then we'll do the other things with you later. And so we got it done in time. Now, there's a difference between the Um, the first party special needs trust, the special treatment trust, and the third party in a number of ways. The the main difference, of course, is where the money can come from, and that is in the third party living irrevocable special needs trust, it can come from any source other than the person for whose benefit it is. So in the case of the special needs trust for my son Jesse, anybody else can put money into it but Jesse himself. So if Jesse has money from his part-time job at a grocery store, or if he receives money because he's receiving Social Security benefits, that's his money and cannot go into the third party living irrevocable special needs trust. You also don't really need to put it in a special treatment trust because there's another kind of bank account I'm going to get into later that solves those kinds of problems. That's the ABLE account. But at the end of the lifetime of the person with a disability, in the third party living irrevocable special needs trust, if there's any money left in it, and the way we plan it and design it is that there will be, that money does not go to the government. It just goes to whoever else in the family or whatever other charity we want it to go to. Whereas with the special treatment trust, consists of money that belongs to the person with the disability himself. That special treatment trust, any money that's left in it at the end of that person's lifetime, does the government of Arizona has first dibs on that to uh, reclaim funds that they spent on the state Medicaid program. The state Medicaid program in Arizona is called Access AHCCCS, Arizona Healthcare Cost Containment System, and they've got a claim to that money in the special treatment trust. Typically, then what we do is we will plan the flow of money in such a way that money is depleted out of the special treatment trust first, so that there isn't likely to be anything left in it at the end of the lifetime of the person. So those of the special needs trust, the most common kind that we create for any family that we work with is the third party living. Um, and there are occasions that we have to do special treatment trusts as well. Sometimes they arise later and the family comes back to us saying, whoops, we got this money. Now, also in your estate planning are these typical documents that actually don't really have too much to do with you dying, so much as what you want to instruct people while you're still living, but maybe incapacitated. And so these are your powers of attorney. There's your financial legal power of attorney, and typically what happens is husband and wife, sign over power of attorney to each other, and then go down a list of who else they trust, siblings and other close relatives and stuff like that, for making legal financial decisions. Likewise for medical, likewise for mental health. For some reason, Arizona does mental health and medical separately from each other. And then there's another document that has the misnomer, it's called a living will. It's really not a will at all, but it's what you want to do with respect to how long you remain on life support, if you're incapacitated, and when the plug should be pulled, and whether you're an organ donor and stuff like that. So those are typical documents in the package of an estate plan that we provide just the same way that any other law firm would provide. And when I say any other law firm, Meridian is not a law firm itself, but we have a lawyer on staff named Jeff Cloud that does the legal documents. Now, my own background, by the way, is I am a lawyer, and I'm also a financial advisor. I've got both of those accreditations, but the lawyer one is a lot older. Um, and the kind of law that I practiced when I was practicing law had nothing to do with wills and trusts or anything like this. Back when I was in law school, I was one of the cool kids sitting in the back of the room. Oh, we don't pay attention to wills and trusts. That's boring. We're going to be litigators. We're going to be criminal lawyers and stuff like that. We do the cool stuff. And here I am, decades later. What am I doing? Wills and trusts. But so my law license actually is for the province of Ontario in Canada. I'm a barrister and solicitor up there, but I've been living down here for almost 30 years here in Arizona. And I don't have an active law license in Arizona, but our lawyer, Jeff Cloud, does. The other personnel in the company, my business partner, Nathan Buckles, um, and he's been doing this actually longer than me, even though he's a few years younger than me. So anybody working with us, I now give them the reassurances that even though I'm getting on in years, the company's going to continue because Nathan and Jeff are a whole lot younger than me, and we're still going to be around. Um, Sooner or later, I'm going to want to spend more time on the golf course. So, not yet, not yet. I'm still doing this for a while. So that's the main legal and estate planning documents. Now, I want to talk to you about something else. While we're on the topic of legal, we need to talk about guardianship. Everything else that I talked about before in this list on the screen is documents that are created at our conference room table. Like we prepare them and we print them up and put them in a nice binder, and then everybody sits down and signs them and stamp them with a notary stamp and get the witness and stuff like that. And these entities, these legal entities, actually come into existence sitting around a conference room table. The trust comes into existence right there. Um, but with guardianship, a guardianship only comes into existence by virtue of a court order. So it requires filing with the court a bunch of paperwork, and it's a lot, and running back and forth a few times and getting a medical report and stuff like that. And the point of it is this: once you have a guardianship order, that means that you continue to have the authority over your child with special needs even after he or she has turned 18. Um, but you don't continue to have the liabilities. And this is a misapprehension that I have to dispel with a lot of people, and that is the fear that if they have a guardianship order over their son or daughter, and then he or she takes a car for a joyride and smashes into somebody's living room, um, the parents' fear is, oh, they'll be liable for that. The reality is, no, they will not. They might be liable if the child is under the age of 18, but not over the age of 18, even if they have the guardianship order. The guardianship gives them the authority over the financial affairs of the child, over medical decisions and so forth, but it doesn't attach any liabilities. And here's how it differs from, say this. We've had some families that opted not to have guardianship over their child, but to actually have their child with special needs, who they consider to be fairly high functioning, to sign powers of attorney himself or herself, so that if mom and dad have to make medical decisions on their behalf or financial decisions on their behalf, they've got the authority to do so through the power of attorney. Guardianship's a bit different. And here's an example. We've got a family, daughter with Down syndrome, uh, and she was 19 or 20 years old at the time, and she got sick, and they had to take her to the ER. And at the ER, the doctors and nurses said, we have to take a blood sample. Well, the daughter with the Down syndrome said, don't stick that needle in my arm. She freaked out about it. And the parents said, go ahead and take the blood draw because we've got medical power of attorney. And the doctors and nurses said, not good enough. Your daughter is awake and aware and lucid, and if she's giving us instructions not to jab her with a needle, we can't do it. Whereas with guardianship, what mom and dad say, or what the guardians say, is overrides everything. They're the boss, and so then the doctors and nurses will follow what the parents say. Other example, I know that my son Jesse, if he's walking through a shopping mall and got approached by somebody selling Verizon contracts, he could easily be talked into a 5-year Verizon contract and service plan and all the rest of it. Under a power of attorney, I can't go to Verizon and say, oh, this is null and void, I'm his power of attorney. They say, tough luck, there's a contract, it's signed. Whereas under guardianship, doesn't matter that Verizon and the sales clerk at the kiosk didn't know that he was under guardianship. That contract is null and void, and there's nothing that's enforceable about it, and tough luck. So it's a more robust protection. There is a kind of limited guardianship where you can say it's guardianship with respect to this topic and this topic, not this topic. We don't see it very often, but it is appropriate in certain situations. So that's legal. If anybody has any questions, please feel free to jump in now, or we can have Q&A at the end. And also, I want to remind you that we offer a free in-person or via Zoom consultation, complimentary. It'll last about an hour or so, for anybody who has their own specific questions and concerns of what it is that that they need addressed in their family situation. And it's a without obligation, free consultation. At the end of the consultation, we'll tell you what we think needs to be done, because everybody's situation is different. Somebody that comes to us with existing legal documents that look good needs less done than somebody who comes to us with no legal documents or bad legal documents. Somebody who comes to us with a certain set of financial circumstances needs a more comprehensive financial plan than others. So it's, we don't know that until we've done the consultation, and like I said, it's totally free of charge. So that being said, we're going to move on to the next topic now, which is going to be um, the government benefits piece, unless anybody has a specific question right now about the legal. Okay. All right. Next question. The next topic: government benefits. This is the whole reason that we actually set things up the way we do with the special needs trust and so forth, and that is because we want to protect our loved ones' entitlements to these all important government benefits. And there's two major categories. There's the cash benefits, and there's the medical benefits. So we're going to talk about cash benefits first. The the first and most common cash benefit from the government is called SSI, Supplemental Security Income. Um, the eligibility criteria are simply attaining the age of 18, having the diagnosis that's on their list of what are the recognized diagnoses, and Down syndrome certainly is one, autism is one, and a whole lot of others. And of course, the most important thing: do not surpass the $2,000 asset limit. And that's why we can't have people with special needs having more than $2,000 in their own names. But we can have $200 million in a special needs trust for their benefit, and it won't count against that asset limit. So currently, the SSI benefit is about $790 a month. It's a federal benefit. Some states top it up. Um, Arizona does not. The more, the states with the highest cost of living, like California, often do. Um, Now, it's the one that arises first. There are some cases where some families are actually receiving SSI for their disabled child, uh, and he or she is below the age of 18. That usually is the case where the person, where the family itself has income below certain threshold limits, and so that SSI benefit will be available. It may not be the full 790. It may be something less prorated because of recognition of some of the family's income. But in the vast majority of cases, there is no SSI benefit for that person with special needs until he or she has attained the age of 18. And you can't, in fact, you can't even apply for it one day earlier than the 18th birthday. But if you're going to get it, we do recommend that you get it as soon as possible after the age of 18, because it's easier to get it earlier rather than later. It's not like you're frozen out from it later, but it it's a little less difficult to do so. So there's again, the all important $2,000 asset limit. Then what's the next Social Security benefit, the next cash benefit that may arise? It's what I call SSDAC. It's a Social Security Retirement Survivor benefit for a disabled adult child. So when, for instance, my son Jesse, well over the age of 18, started receiving the SSI benefit, once I started taking my own Social Security benefit, even though I'm working, I'm over the age of the retirement age, so I can take it. What that did was it transitions Jesse to 50% of my Social Security retirement benefits. So if, for instance, Jesse was getting the 790 from the SSI, but then I started taking my Social Security retirement, and say my Social Security retirement was $2,000 a month, then what Jesse goes to is 50% of that, which is $1,000 a month. And so obviously he's not going to get both, but he's going to get the higher of the two. And in the case of, say, two working parents, if the second working parent retires later and has the higher Social Security benefit, then then Jesse would go to a higher level still. So it's something that we plan around, knowing that once I'm in my retirement phase, or any parents in their retirement phase, there's going to be, say in Jesse's case, $1,000 coming to help sustain him in the here and now. Now, then what happens when I pass away? Then it becomes 75%, so that Jesse getting 50% of my Social Security retirement benefit of $2,000 is getting $1,000 while I'm alive. When I pass away, that goes up to $1,500, 75%. Um, and in the case of families with more than one child with special needs, that usually still holds true. There may be, at a certain point, there could be a family maximum. It's usually not hit with 2 kids, and oftentimes not hit with 3 kids, but it can get hit, once you're beyond 3 kids, you might be hitting maximum in the family. That has to be prorated. Now, another kind of Social Security benefit is SSDI, and that might come into play in the case of a child who is able to work and has actually been contributing into the Social Security and disability, in Social Security system for 40 quarters. And then they could actually be getting SSDI on their own record. It doesn't often happen, but it can. Um, in any event, it's there. It's possible. Some of the families that we've actually had people that work as, say, you know uh, lunch cafeteria superintendents in schools and stuff like that, where they're able to work jobs like that, and if they can actually build up 10 consecutive years of working, then they've got their own record for Social Security disability. And then if their condition deteriorates and they can qualify for disability, then they get that. Now, the medical benefits are next. And the medical benefits can even be more valuable than the cash benefits, depending on medical need. So for instance, um, doing the math on the cash benefit, over the course of a lifetime, say from age 18 to age 90, if you look at those cash benefits and how they increase at certain steps and stuff like that, from age 18 to age 90, we're talking of something that's going to accumulate, going to add up to being over $1 million. With the medical benefits, you don't know. It could be not much, or it could be multiple millions of dollars, depending on medical need. Now, the medical benefits that arise, there is, first of all, Medicare, but actually Medicare doesn't happen in most cases first. It happens secondly. So for instance, after I've been on Medicare for 25 months, then Jesse can have Medicare as his primary health insurance. But prior to that, what he's been on is Medicaid access, which is the government benefit program of medical coverage for people with disabilities or people with low incomes. And access in Arizona is actually a fairly good program. We deal with clients in other states that sort of get skittish about even thinking about their child being on their state's Medicaid program. It's not a bad thing here in Arizona. It's actually been a pretty good program, and so there's nothing wrong with having it. And it can be, like I said, it's invaluable. First of all, it's picking up your medical expenses now before your child gets on Medicare, and Medicare takes over as primary, and Medicaid, the access becomes secondary. Also, for anybody who has private insurance that your child is on, of course, the private insurance is always going to be the primary, but then as long as you're on access, Medicaid, then that's going to be the secondary that then kicks in for the deductibles and the copays and so forth. So you have minimal out-of-pocket expense. It's important to have that, because those copays and deductibles can be very expensive, because primary health insurance doesn't cover a whole lot the way it used to. So you want to have that. And when you get the SSI benefit at age 18, it's going to basically automatically enroll your child in the access program as well. Now, the funny thing is, you can get them on access before, and oftentimes here in Arizona, we have families where the kids are already on the access program, the Medicaid program, even though they're under the age of 18. That's because there is no means testing in Arizona to be on it. The simple disability alone, once you're in the DDD system, will qualify you for the access benefit, uh, provided you've got, you meet the other qualifying criteria. Whereas in other states, again, you can't get on their Medicaid program without showing, some level of parental poverty as well. That's not the case in Arizona. So these government benefits are worth millions of dollars. You don't want to have things set up that are going to deprive your child of those benefits because you didn't create a special needs trust or they received funds in the wrong way and they suddenly got knocked out of having those benefits. And you got to realize that government agencies are looking for ways to deny benefits to people, so you want to tread carefully. Um, anyway, now, any questions about the government benefits? It's over, like I said, it's it's worth millions over the course of a lifetime. So, you know, an investment now to set things up properly is going to pay off many, many times over by doing it right. Now for the future. Now, on to the next topic, doing the financial planning. Um, I've talked to you about legal stuff with the legal hat on. Now I'm going to talk to you about financial stuff with my financial hat on. And so let's get into that. So first of all, we talked about using my son Jesse as an example. So planning for his situation after I passed away, after his parents passed away. Um, I've looked at the Social Security benefit he's going to be getting after I passed away, and it's $1,500, right? So we know we've got the $1,500 from Social Security. You know, it's nice to know that. What about any other income streams? PWSN, you see that on the screen there, any other income stream for the benefit of the PWSN, that stands for person with special needs. It's our acronym for that in the industry. So there could be other income streams, and they could be such as, for instance, um, teachers in public school systems here in Arizona. They're going to be in the Arizona State Retirement System, as are other government employees going to be in ASRS or federal employees. So you could be in the kind of employment that has a pension plan that has a survivor benefit, such as the Arizona State Retirement System, or certain very, very large companies still have pension plans too that may have survivor benefits. So you got to look at that. So for instance, I know with some of my clients that have been long timers in the military, they've got a military benefit that has a survivor benefit where they can designate 55% of their military pension can then continue on to their child with special needs. So we need to look around for those. They're not as common as they used to be, but we do need to look around for those. So anybody who's teachers there, that's, take a look at your ASRS statements. Then we have to ask, okay, what is the monthly budget that we need to take care of our child using today's dollars? So if, for instance, I know that what my son Jesse is going to need in today's dollars, to cover his rent, to cover his transportation, to cover groceries and sharing expenses, say in some sort of a group home setting later on, or contributing to the cost of his living with one of his siblings and so forth. I'm going to say that in today's dollars, his monthly budget is going to be $2,500. We know that he's going to be getting $1,500 from Social Security. So what's the shortfall? The shortfall, doing the math simply, 2,500 minus 1,500, that's a shortfall of $1,000 a month, which is $12,000 a year. So, okay, how are we going to make up that $12,000 a year? Well, you do the math of what is a lump sum that's going to generate enough income to cover that shortfall. We use as a reliable rule of thumb, we use the number 4%. That is, you can pretty much expect that over the long haul, a wisely invested sum of money will be able to generate, on average, 4% in income without eating into the principal. In other words, it's got to actually be growing at 5.5 or 6% But we take 4% for income, but leave the other 1.5 to 2% in there to cover, for the inflation that we're going to have to worry about to keep the capital growing. So it's going to keep generating the income we need. So doing the math with respect to the 2,500 minus the 1,500, what Jesse needs is $12,000 a year at 4%. The lump sum that will cover that and generate the $12,000 a year is $300,000. But the bad news is then we have inflation. So you got to go to the consumer price index websites and stuff like that. And generally what happens is you plug in the numbers and they tell you, okay, the $300,000 that you're talking about being sufficient now to cover inflation that's going to be, well, what it looks like in 30 years from now or so, that's going to be $600,000. So very often a number that we do arrive at with families is something in the neighborhood of $600,000, sometimes higher, sometimes lower, and oftentimes when I'm doing a live presentation, we get a whole lot of people taking deep breaths when they hear that. But the reality is it's not that hard to get to if you start working at it, early enough. It's not that daunting a figure. So we start looking at, okay, what are the assets and the strategies that we have to get there? Working on it earlier, the better. What do you have in savings, in IRAs, 401ks? What's the house going to be worth in the future? Are you going to downsize it and therefore free up some capital that you can then put into the special needs trust? Sources from families, inheritances, and stuff like that. And and life insurance for some people, life insurance is the most guaranteed way to make sure that a lump sum is going to drop into the special needs trust later on. Now, life insurance is cheaper when you're younger and more expensive when you're older. So I'm not often in the position of recommending life insurance for anybody past the age of 50, usually not even past the age of 45. And I never want us to be thought of as people that sell insurance. There are other entities in town and throughout the country that have, special needs planning departments, and they claim to specialize and understand what the needs are for special needs. But some of these are insurance companies like Mass Mutual. And so surprise, surprise, it always seems to be that the solution they recommend for any situation ends up going back to insurance. Well, maybe, insurance might be the right thing, but you know, it gets expensive. We're talking permanent insurance as opposed to term insurance because the insurance has to be there, as long as you're alive, and as opposed to cutting out after 20-year term. You're still going to be around after 20 years, and then the insurance is gone. You need the permanent kind, and that costs a lot more in premiums than term. And so you have to be able to make sure that you can budget for it. Now, one of the things that's interesting about having that kind of permanent insurance, though, is for certain kinds of cases, you may discover later in life that your child is has developed okay, and we don't need to fund the special needs trust at all. Well, with permanent insurance, then at a certain point, after 10 or 12 years of putting money into it, you can actually cash it out and say, no, we don't need this death benefit anymore because things have worked out well, and I can get my money back now. So it's not like that money is lost. It actually builds up a cash value that you can then redeem if it turns out you don't need it. But you have to have had the budgetary capability during all those years leading up to it to be able to pay those premiums. And the reality is, it's a chunk. We did it once in an interesting way with a family um, that didn't have a whole lot of high income themselves. Just a couple of moderate level jobs. But the mom inherited about $45,000 from her own mom, and what we were able to do with that was take that $45,000, since they didn't need to pay off any debt or anything like that, take that $45,000 and put it into an annuity that then was guaranteed to keep paying the premium on life insurance forever. Um, so, since the money, the $45,000 inheritance wasn't needed for anything else, and it never would have been enough on its own to just set aside and just use that to pay the premium on life insurance. It would have run out eventually if you just had it in a savings account or something. But you put it into an annuity that guarantees a stream of income for as long as the annuitant is alive. then you've got premiums covered. And then when the mom herself, not the grandma, but the mom passes away, the annuity then just, has, it ends, but the life insurance then kicks in. It's been kept going and it's always been, up to date with the premiums. And there's the life insurance that is then dropping the $500,000 or $1 million into the special needs trust. So you can get creative. You can leverage money in a variety of interesting ways. Um, Now, I want to talk about this other thing I mentioned earlier, and that's called the ABLE account, because it's a financial topic. And that is this. Um, Starting in a few years ago, Congress actually in the end of 2014, Congress passed an act called the ABLE Act of 2014, ABLE, standing for Achieving a Better Life Experience. And what that did was it created for people with disabilities the same kind of benefits that college 529 plans have, where money can be set aside and saved for a certain purpose, and it has certain tax benefits to it where it's not taxed as it goes in, and so forth. And so we've got ABLE accounts. And so, for instance, with my son Jesse and his Social Security benefits and his employment from his income from part-time employment at an AJ's grocery store, um, we use the ABLE account because any money that goes into that up to a certain limit does not count against the $2,000 asset limit. So in any given year, you can put $15,000 or maybe 15,500 now into an ABLE account from any and all sources. It can be from Jesse's money, it can be from an aunt's money, or uncle's money, or friends' money and stuff like that. It can come from any source, provided that it's not more than $15,000 a year, and provided that the total amount of the account doesn't exceed $100,000. Normally, we'd never let it get that high. Now, when this first came out, we thought, wow, we didn't know the details of it. We thought, well, maybe you don't need to have special needs trusts anymore. Well, since we know that it's so limited in the amount of money that you can actually put into it, it's clear that you still do need special needs trusts. But the ABLE account is useful so that when Jesse, this way Jesse can have a bank account that has a balance of more than $2,000, and as long as it's an ABLE account, it doesn't put him over the asset limit for his Medicaid benefits and Social Security benefits. So it's important to have those, but they're not the panacea for all all the financial planning and budgeting that you're going to do with a child with special needs. But it's part of the arsenal that you use there, so that you don't trip over that $2,000 asset limit. Now, it's important to recognize that while some of these benefits, like for instance, the Social Security SSI benefit is the one that is means tested, where there is the asset limit of $2,000. But once Jesse's gone on to the benefit that is derived from 50% of my retirement benefit, that's no longer means tested. So he could have money in his own name over $2,000 because it doesn't depend on that means test anymore. Unfortunately, that doesn't get us out of the woods with respect to the Medicaid benefit, the access benefit. You still have to stay under the $2,000 asset limit because of that. Therefore, you need the ABLE accounts. Therefore, you need the special needs trust. It's not, because Jesse being on the kind of Social Security cash benefit that isn't means tested any longer, he's got other benefits that are means tested. You still got to do these other things. Now, any before we get on to the future lifestyle, any other questions about the financial?
There was one
I'm going to
question
ask them at the
about,
end.
well, there was one question since you're just talking about the ABLE accounts. So the ABLE accounts,
Yeah.
you can set them up before they're 18. I know that is correct because we have some
Yeah.
for our little ones. But what does it cost to open an ABLE account? My recollection
You
is
can
it's
go
not
to the.
much.
It isn't much at all. Probably no more than just the usual, bank minimum deposits and stuff like that. You go to a website called ablenrc.org, ablenrc.org, to get the details about ABLE accounts, and it'll show Arizona's. It'll show other states too. There is no reason. There's nothing that mandates that you use Arizona, but we recommend that you do, just in case there is a future state income tax benefit to it. They haven't made one yet, But if they're going to make an income tax benefit at the state level for it, then you want a state, a plan that's in the state of Arizona. So you go to ablenrc.org, and that will then guide you to the financial institutions that will actually hold able accounts. It's not any bank. It's just certain ones that are listed there. Any other question about able accounts or anything else? Financial? Okay. The future lifestyle. This is where you put together a non-legal kind of document. It doesn't need to be notarized or witnessed or anything. It is a day in the life of your child. And it's where you put in all the instructions that are necessary for anybody who's going to be involved in their future care, off into the distant future, or even for an upcoming weekend where mom and dad are going to go away for the weekend, or for when there's a new caseworker coming in. Not that there's any turnover in caseworkers, is there? But the future lifestyle document, called the letter of intent, can save you a lot of time and effort in imparting this information to other people. You can put it into this written document called the letter of intent, and it's a 19-page template that, when you fill it in, becomes a much longer document than that. And we've developed this 19-page template over the 30 or so years that we've been working with families. You would never be able to think of all these things that you want to tell other people about your child if you're just sitting down at your dining room table with a blank pad of paper. But this questionnaire does it for you, and then you update it year by year. So it's who are the doctors, what are the medications, what are the diet restrictions, what are the abilities, what are the disabilities. So, and for instance, my son Jesse's pretty good at operating a microwave oven, but I wouldn't want him to operate an outdoor barbecue grill. So that's the sort of thing that I would put in there, because he might want to talk somebody into letting him operate the outdoor barbecue grill. Heck, you might try to talk somebody into letting him drive. Okay, but it's, so you got to sort of put these warnings in there, but at the same time, you don't want to have a future caregiver constrain your child too much and prevent him or her from doing things that he is able to do, that she's able to do. So we've done this over 25 years, and the detail you put into it depends on how verbal he or she is. So for instance, you're going to put in a lot more detail with a non-verbal child than with a verbal child, unless the verbal child is also a con man who can talk people into anything. They got to be warned. My son Jesse, for instance, he's able to read, and he can read instructions. That doesn't mean he's going to pay attention to instructions. So don't expect him to understand the instructions on a box of rice of how to cook it on the stovetop. And also, funny example is, in the shower, he's not going to pay attention to which is the shampoo and which is the conditioner. So you got to get him the kind that's both, because he's going to put them on in the wrong order. So it's those sorts of things. Yes, he can read, but that doesn't mean he's really taking it in. So it's all of these things: the medical care, your religious observances, the schooling situation, and so forth. And you update this year after year, so that then people stepping into the picture know exactly what's going on, or can get to it quickly. And you can also supplement it with videos of certain activities. This is how your child gets dressed, and what what assistance they need with dressing, or this is these are their social activities and stuff like that. So you're able to change this, and we recommend you do it on your child's birthday. It's a very useful document for when new caseworkers come into the picture. I remember, when my son was younger, it seemed that the DDD caseworker changed every 6 months. And so we'd end up with a 2.5-hour meeting every 6 months with a new caseworker. It was very time consuming, tiresome, and boring. But if we could give that person something like the letter of intent that we filled out in advance, that meeting goes from 2.5 hours to a half hour. And it saves a lot of time. And the people at DDD would prefer it that way too. When we presented this once at a group of people, that work with DDD down in Tucson, they stood up and applauded when we told them about this feature, because they need their time saved too. So it's important, to have that, and it sort of ties it all up. There are things about my son Jesse that even his younger siblings don't know, because they've been away and off to school and stuff like that. And so if he's developed a certain liking or disliking for certain foods and stuff like that or allergy to something, they might not know that. You put it in here because they're, his younger siblings are going to be involved with his life later on. They need to know these things, that he can't have licorice or something like that. Um, then, point five, which is sort of arises out of the others, is implementing. So if we've actually, built a living trust for you, if we've actually done things with, if we've actually worked with you, then the actual implementation. So it's one thing for us to create a living trust for you. It's making sure that the right assets are then titled into it. So for instance, you know, creating a living trust, but then still leaving the house in your own personal name and leaving, big savings accounts in your own personal name. You haven't done a whole lot. You actually got to retitle things into that living trust. So there's the implementation of that. You look at your any insurance or 401ks and so forth that might have beneficiary designations that could accidentally be leaving something directly to your child with special needs. You got to change those so that the beneficiary is renamed as either your child's special needs trust or your living family trust, which then in turn is leaving it to the special needs trust. So you got to check all those beneficiary designations. And that's one of the things. If you go to a traditional financial advisor saying, I got a child with special needs, I want to, get a financial product that's going to generate an income for him later on in life. A traditional financial advisor, not knowing about all these ins and outs and tricks and pitfalls of special needs planning, may just say, okay, here's an annuity, or here's an IRA for you that has a beneficiary designation at the end saying that it goes to your kid, and may think that that's perfectly okay because that was what you told him. But it's not okay. It can't go directly to your child. Um, then other implementation. We when we do financial planning, we're using software that is more than just plinking around using, Microsoft Excel. We're using very sophisticated software that is housed on a server in some other state, which calculates what the likelihood is of achieving your goals if you leave your assets this way according to the way your 401k is invested and stuff like that. And we might come to the conclusion, well, the way it is right now only gets you to 45% odds of success. We've got to get to 70% odds of success. So if we make your investments a little more aggressive if you're young, or a little less aggressive if you're older, and maybe take something out of something that's not doing so well and put it into something else, then we can get there. So that reinvesting certain things, reallocating certain things, or completely changing certain things and selling certain assets. So we implement those things for you, and we do a very comprehensive financial plan that ends up being 60, 65, 70 pages long of what we recommend that you do. What we recommend isn't necessarily what you have to do. It's not mandatory on you, but it's our obligation to give you this recommendation. In other words, we told you need special needs trust. We told you what the budget is for your child to be sustained later in life. Then how do we get there? And this is, we have to give you a financial plan, a strategy to get there. As to whether or not you follow it, that's entirely up to you. But without a financial plan, without that financial strategy, creating the special needs trust and those other legal documents, but that special needs trust, just creating that without the strategy for financing it is like having a nice looking car in your driveway that has no engine under the hood. So you'd have to have, you've got to consider the financial strategy too. If life insurance is going to be part of it, then we help you with the applications for life insurance. We can find you the best rates and best quotes on life insurance. Because we are insurance agents as well, even though that's not what we lead with. If that's the appropriate, if the appropriate consideration, the appropriate thing is life insurance, and that's what we go to. And sometimes it is. And sometimes it's one of the many other things that we can do with moving financial assets around. So that's the last piece. Then on to the next, and that is Q&A and follow-up. Anybody, any questions that you want to ask now, or if you would like to schedule a complimentary consultation with me, either via Zoom or at my office. We're back having in-person meetings now. So if you'd like to set one up, I mean, if anybody wants to put up their hands and say, you know what, my calendar is right next to me, and I I know when it is I'd like to meet with you. You can tell me now, or I can send you emails afterwards and give you the chance to. Anybody want to,
Cliff.
ask any questions? Go ahead.
Yeah, Cliff, thank you so much. This was so informative. And what I love about the company that you've built is that you have everything under one house. And you don't find that very often where you have people that really specialize in all of the different components of special needs planning. So, like when my husband and I set up our stuff, we were going over here to this firm and then we were going over here to this financial institution. And it's so nice that you've made it so easy for us because it is difficult. It's a difficult thing to wrap your head around how many different components there are. And if you have to juggle different organizations between those different components, then that gets really confusing. And so, what I love about what you guys do is you do everything in one place, which makes it very streamlined and easy and exactly what we need in our lives is something that is easy and streamlined. So I really
That
appreciate what you've built here.
I'm glad that you've mentioned that. It's very uncommon to find it all under one roof.
Yes.
And I know of somebody else in Massachusetts and somebody else in Minnesota, and then there's us. So there isn't that much of it out there. And part of it is this: a lot of financial advisors, they're hunting for big game. That is,
Yeah.
they want to find what they call high net worth individuals and just catch them as they're about to retire and cash in their 401ks and just make their money that way with people that have millions and millions of dollars. Whereas the range of families with children with special needs is the entire economic range, and so we're looking at it at that level. And so
Yeah.
we're financial advisors that aren't looking for the elephants in the jungle. We're looking to help everybody.
Yeah, I absolutely love that. I mean, really, it is unique and it is beautiful and it is something that only a special needs father would create, right? Because you know that it is needed and you saw the gap and you filled it, which I think is absolutely amazing. We did have two questions on our Facebook Live, and one of them was, can a home that is paid off be put into a third party special needs trust?
The answer to that is yes, provided that the owner on title isn't the person who has the disability.
Okay, perfect. And then the other question was about ABLE accounts. So we have one person who said she set up an ABLE account in another state. Is she allowed to transfer that money to Arizona and an ABLE account in Arizona?
Yes. Yeah, you can set it up and move it over. You can't have two existing label accounts at the same time, so there's going to be some coordination between the two because
How do
one
you
person
do
can only
that?
have one able account.
Yeah.
To be honest with you, it depends on the bureaucrats in each state as to how they want to do it. So I can't answer that because each state is going to have a different protocol.
Okay, so they should just basically call you.
Yeah, basically, yeah.
Okay, because there's a
Tennessee
lot of
is one thing, it's
bureaucracy in
Ohio.
these things, right? And you need
Yeah,
a guide
yeah,
to help shepherd you through it.
right.
I really,
Right
I
now
really,
there's no harm. There's no harm in it being in another state because there isn't, yet any benefit other than convenience and locality for Arizona. But Ohio, before Arizona had it set up, we were actually recommending Ohio and Tennessee.
okay. Yeah, because they're all different, right? And they all have different benefits and different things that happen at the end of life. So I know that for a few, I don't know if it's all ABLE accounts, work kind of like that special treatment trust where the money goes back to the state or the state gets first dibs on any remaining
Exactly.
money in the ABLE account. And I didn't know that about the special treatment trust. And to be honest, I didn't even know what a special treatment trust was. So I was like, oh, that's something completely new. And
Yeah.
it's absolutely amazing just all of the different layers that um, go into special needs planning. And thank you so much for coming on today and for really laying out all those different components. And I thought that I loved that you included at the end implementation, because that is such a big step, because you get all of this stuff done with the lawyers and you're like, yeah, I'm done. And it's like, oh no, you have to actually go and get the names changed on everything, which is a lot of work.
Yeah, yeah. And filing a deed with the county recorder for your house and stuff like that. You know, it's, you know, you're not finished when you leave with the binder of documents.
That's right. That's absolutely right. Yeah, what you have built is truly amazing. And thank you for it, Cliff. Thank you for being here today and for sharing so much wonderful information with us.
Thank you, Michelle. Thank you,
All
everybody.
right.
Great to
Thank
see
you,
you.
everybody who
Okay.
showed up.
Okay.
And we look forward to seeing you at our next webinar. Bye, guys.